evening, everyone. Lovely to see you back, those of you who were with us this morning, and welcome to those of you who have just managed to find time and come to this seminar. I know you're busy with your employers, the serious attorneys that don't give you any air to breathe during the working hours. It's my pleasure to reintroduce you, not to introduce my friend Ingeborg. Was happy to devote 2 hours of her time today to have lectures for you at our Faculty of Law and to share her extensive knowledge on the CISG with you. So she will start where we stopped in the previous panel with the gap filling and interpretation of both the CISG and maybe contracts as well. And then, depending on how much time allows us, she will continue with what was supposed to be her topic for the afternoon session, and that is conformity to the good. After Ingeborg, we'll have Đorđević joining us again with the presentation of entities. We might have a little panel improvised discussion on exclusion of liability, because unfortunately, Professor Schroeder's slide is delayed, so he won't be here until after midnight. And I'm not planning to keep you that much longer. And in the very end, our dear colleague Benjamin Gottlieb will give you some thoughts and share his practical experiences from the legal practice as an attorney on how CISG fits with the attorney's work. Ingeborg, thank you so much once again.
Thank you very much, Milena. Welcome back those who have been here this morning, and welcome all the others who are attending this class this afternoon. This morning we decided, I didn't finish interpretation and gap filling, unfortunately, so we decided that I go on with gap filling and contract interpretation, especially because this is a very important subject matter for this Wismut. So we decided the Mooties have priority here before turning to the conformity of the goods. So I'll talk about gap filling. And usually, and like we find it in Article 7, interpretation is juxtaposed to gap filling in the CISG. Well, in reality, the line is more or less blurred, because you might say something is an interpretation of the CISG, or you might say, well, there's a gap in the CISG that we have to fill according to the principles laid down in Article 7, Para 2. I'll give you an example. If you have a look, you all have the CISG in front of you, yes? If you have a look at Article 79 of the CISG, exemption from the liability in damages. It says a party is not liable for a failure to perform any of his obligations if he proves that the failure was due to an impediment beyond his control and that he could not reasonably be expected to have taken the impediment into account at the time of the conclusion of the contract, or to have avoided or overcome it or its consequences. So the question arose, and it has been highly debated, and there are actually 2 CISG Advisory Council opinions on this. The first one by Professor Alejandro Garro that you heard this morning. I think it was opinion number 7 on exemption under Article 79, and then we had a second opinion on hardship under the CISG, and that rapporteur was Professor Edgardo Munoz, who also know by now. And so we dealt with the question actually twice, whether hardship is dealt with by the CISG. Hardship means that the equivalence of the 2 contract obligation becomes imbalanced due to outside circumstances, for example, a development of the market or the like. So the question is, hardship is not mentioned in Article 79. And if you go to civil law jurisdiction, you will have 2 concepts. You will have the concept of impossibility And you will have the concept of hardship of the Latin words clausula rebus sextantibus. So what happens if the circumstances have changed and lead thus to an imbalance of the obligations of the parties? So the question is, does the CISG in Article 79 only deal with this traditional force majeure situations, like impossibility especially, or does it also encompass hardship, which is an economic impossibility, if you want to call it that way? So the text of Article 79 does not tell anything about hardship. It simply speaks about impediment. Yeah, also a term that you don't find in domestic legal systems. There you find impossibility or frustration in common law legal systems or the like. So the question is that then a question of interpretation of Article 79, whether impediment also relates to hardship? If hardship leads to the non-performance of the contract, or is there a gap in the CISG because it does not explicitly deal with hardship, like, for example, the unit droit principles? The unit droit principles clearly distinguish between force majeure on the one side, where they have a similar provision like Article 79 CISG, and then they have, even in a different part of the unit droit principles, they have rules, and extensive rules, 3 rules on hardship, on the consequences. They define what hardship is and on the consequences of hardship. So you see, that question is open. Is it a question of interpretation? Actually, the CISG Advisory Council treated it as a question of interpretation and came to the conclusion in both opinions, opinion number 7 and opinion number, I think it was 19 or 20 probably, that hardship is governed by Article 79 of the CISG. Thus, it is a question of interpretation of Article 79 of the term of impediment, and it's not a gap in the CISG that has to be filled according to Article 7, Para 2. So this is just to show you that in many cases you cannot really tell, is it a question of interpretation or is there a gap in the CISG? Therefore, it is difficult to decide, does Article 7.1 or Article 7.2 apply? Well, I think in the end, the practical outcome more or less is the same. So in many cases, we do not have to decide whether it's interpretation or gap filling. So let's have a look at Article 7, Para 2. Let's read Article 7, Para 2. Questions concerning matters governed by this convention, which are not expressly settled in it, are to be settled in conformity with the general principles on which it is based, or in the absence of such principles, in conformity with the law applicable by virtue of the rules of private international law. So the first point is that we have to distinguish between so-called internal gaps that are within the convention and so-called external gaps, that means matters that are in principle not governed by the convention, that are outside of the convention. So the crucial question we have to ask under Article 7, Para 2, is it a matter that is governed by the convention? Because only then we come to the conclusion that it is an internal gap that we have to fill according to the principles laid down in Article 7, Para 2. So, again, to answer this question, what are matters governed by this convention, we have to especially look at Article 4, the provision that was discussed by my colleague, Professor Edgardo Munoz, this morning. Article 4 tells us what matters are governed by the convention. Let's go back to Article 4. This convention governs only the formation of the contract of sales and the rights and obligations of the seller and the buyer arising from such a contract. In particular, and then comes a very, very important sentence, except as otherwise expressly provided in this convention, it is not concerned with the validity of the contract. So we have to go back to Article 4 in most cases to decide whether a matter is governed by the convention or not. And whether a matter is governed by the convention is again to be analyzed by an autonomous interpretation of the CISG. I tried to explain that to you this morning with regard to validity, so that it is the CISG that decides whether something is a validity question, and only if the CISG comes to the conclusion that it is a validity question, then it is a matter outside of the CISG, like, for example, fraud or unconsciousness of a contract, illegality, and all that stuff. Those are validity questions that are recognized by the CISG. Likewise, I might give you another example. The CISG is concerned with substantive law, the law of contract. It is not concerned with procedural law. But again, the question whether something is a substantive law issue or a procedural law issue is not left to domestic law, but it is decided by the CISG. I'll give you again some examples. For example, the question of interest for us as civil law lawyers is clearly what? Substantive or procedural? Interest of a sum that is due. Is it dealt with in procedural law or in contract law?
It's a substantive provision.
It's a substantive matter. Thus, we would say it's covered by the CISG. However, if you go, for example, to US American procedural law, you will find that they split the duty to pay interest of a sum due, interest until a decision is taken by a court, that is a substantive issue, but after that time, interest on a sum that has been already put down in a decision, in a court decision, is a procedural law issue. So again, if we would allow this distinction under US law, that it's partly only substantive and the other part is procedural, we would have, that would lead to non-uniform consequences. Yeah, so we have to look at the CISG, and there we have Article 78, and Article 78 simply says that interest is due on any sum that is in arrears. Yeah, any sum due, whether it has been stated positively in a court decision or not. Thus, the CISG treats interest in the whole as a substantive issue. We won't leave it to procedural law, although some domestic laws might say that it is a procedural question. So it's not only validity, there are many, many more questions that we could discuss, whether what are matters governed by the CISG, and all that I want you to always remember is the autonomous interpretation. It is not domestic law that tells us whether something is a validity question or procedural law. It is the CISG that decides whether a matter is governed by the CISG. So what are the consequences if we find such an internal gap, a matter that is governed by the CISG, but is not, under Article 74, is not expressly settled in it? So where do we turn to? And the first answer is these questions are to be settled in conformity with the general principles of which it is based. It refers back to the convention. Yeah? So we have to develop general principles from the CISG itself, and by relying on these general principles, fill this gap within the CISG. So there are numerous general principles that can be found in the CISG, and I would say the older the CISG becomes, the more general principles we can indeed develop from the CISG. So certainly there are principles like party autonomy, estoppel, protection of reasonable reliance, reasonableness in general certainly is a general principle under the CISG. Favor contractus, that means wherever you can interpret a contract so that the contract is valid or that an obligation is valid, then you have to interpret it in this favor. Burden standard of proof now also are regarded to be covered by the convention. Yeah, burden of proof is more or less no longer disputed, except for some US American colleagues who still debate this question. Standard of proof is more debated. The CISG Advisory Council already back in its, I think, 5th or 6th opinion said that both questions are matters governed by the CISG, covered by the convention, and decided that the standard of proof should be one of reasonableness, relying on the general principle of reasonableness. So the standard would be, is a fact proven with reasonable certainty, and that would be the standard of proof under the CISG. Full compensation is certainly a general principle that you can derive from Article 74 of the CISG. Right to withhold performance, there are several provisions that contain such a right under certain circumstances that you can apply to other situations. There has been discussions whether set-off is also governed by the CISG. You will find also a CISG ASIO opinion on the CISG and set-off, and certainly certain aspects of set-off are governed by the CISG. We can find general principles in some of the provisions of the CISG, like, for example, that remedies, and set-off certainly also is remedies are exercised under the CISG by declaration, yeah, which is very important regarding set-off, because you have some legal systems where set-off takes place automatically, ipso jure, yeah, whenever you have two monetary obligations that face each other, they erase each other as far as they are congruent. So you have these legal systems where it is ipso jure or ipso facto set off. Then you have other legal systems like the French legal systems where you have to go to a court to declare set off. And then you have a third group of legal systems where set off is exercised by declaration. Yeah? And all the remedies under the CISG, if you look at that, are exercised by declaration, be it avoidance or reduction of the purchase price and also damages and so forth. So it is fair to say declaration of a remedy is a general principle under the CISG, and that can also be applied to set off. Yeah, I said I put a question mark to the question whether the unit drop principles can be general principles under Article 7, Para 2 of the CISG. This has been advocated by UNIDROIT-friendly scholars, as I mentioned already this morning, with regard to Article 7, Para 1. So the same is true for 7, Para 2, gap filling. Some advocate that you have to fill gaps within the CISG by relying on the UNIDROIT principles. For example, this has been advocated with regard to hardship, because the CISG does not contain an explicit regulation of hardship. It has been argued there is a gap against what the CISG Advisory Council decided later. That opinion we decided, it was in 2020, February 2020 in Mexico. This opinion was agreed upon by the CISG Advisory Council on hardship. So we decided there's no gap, so we didn't have to fill anything. But there are scholars arguing there is a gap in the CISG, and we have to fill it with the UNIDROIT principles, and with consequences that, according to the CISG Advisory Council, rapporteur was Professor Munoz on this question, according to our opinion, would undermine uniformity and would not go along with the CISG, these principles laid down in the UNIDROIT principles for cases of hardship. So, I do not think that the UNIDROIT principles are general principles in the sense of Article 7, Para 2 of the CISG. Thus, even if we find a gap in the CISG, an internal gap, and even if we do not find general principles in the CISG to fill in this gap, we should not turn to the UNIDROIT principles to fill the gap. Okay, so last resort, if we cannot find general principles in the CISG, which will be rare cases, then we have to turn to the relevant rules on private international law. That means the law of the forum, if we have litigation in domestic courts, to decide which law is applicable outside the CISG to the contract, and then apply this law to fill the gaps even within the CISG. As I said, this should rarely be the case. Now let's come to interpretation of contract. I told you, please strictly distinguish between the interpretation of the CISG under Article 7 and interpretation of the contract under Article 8 and 9 of the CISG. Again, just to give you an idea again of the difficulty to come to such a uniform convention. Again, we have very differing starting points in the civil law and in the common law with regard to the interpretation of the contract. And this is closely related to what I told you this morning, namely the goal of civil law to have fairness in the end, and the goal of the common law to have predictability, And from that, we have different starting points for contract interpretation. what is the starting point in civil law for contract interpretation? What are you looking for? I guess I'm pretty sure that you also have the starting point. The starting point. What are you looking for? When you have, yes?
Or maybe the terms of the contract.
The terms of the contract, okay, but what are you searching? What is the aim you want to find out? The terms of the contract are a means to come to that end.
Of the mutual will of the parties.
Wonderful. The mutual intent or will of the parties. So it's a subjective approach, the civil law approach. They want to do fairness to the parties, because even if they expressed something differently, they might have had a mutual intent. Okay, so this makes interpretation maybe sometimes unpredictable, because it's subjective. How do you find out that you cannot open the heads of the contracting parties, look inside, even what did they mean at that time when they concluded the contract? So the other starting point in common law is based on predictability. And predictability is given once you take an objective approach, yeah? I do not care what the parties thought inside, yeah? I look, what would a reasonable party in the shoes of the respective person have understood or meant, yeah? Because in the end, if it comes to a dispute, party A says, well, I meant X. Party B will say, oh no, I meant Y. And we agreed on Y, not on X. So you'll have difficulties to find a mutual intent of the parties, a common intention that is different from what an objective reasonable person would have thought if it looks at the contract. Okay, so we have two different starting points, and again, there was a lot of discussion in Vienna. Let's have a look at Article 8, and let's have a look which side prevailed on that question. Para 1. For the purposes of this convention, statements made by and other conduct of a party are to be interpreted according to his intent, where the other party knew or could not have been unaware what that intent was. So it's clear, the civil law countries prevailed. Yeah, that's the starting point in Article 8, Para 1. But the truth is, reality is that in most cases where there is a dispute, you cannot find out what the real subjective intent of a party was. They will pretend anything that is beneficial to them. So, Article 8, Para 2. If the preceding paragraph is not applicable because we cannot establish a common intent. Actually, I forgot to say, Article 8, from its wording, only deals with the interpretation of a declaration by one party. It does not directly deal with an interpretation of the contract, but that's the core for it. It's the interpretation of the contract, not only the interpretation of a declaration. So 8 Para 2, if the preceding paragraph is not applicable, that means if I cannot establish a real intent, statements made by and other conduct of a party are to be interpreted according to the understanding that a reasonable person of the same kind as the other party would have had in the same circumstances. And here comes in the common law approach with a reasonable person. And in most of the cases, I would say 99% of the cases where there is a dispute about contract interpretation, we cannot rely on Article 8, Para 1, but we have to turn to Article 8, Para 2 and ask ourselves, what would a reasonable person have understood when we look at the terms of the contract? So we have in principle, the starting point is civil law, but in practice it will be the common law approach, the reasonable person approach. And now comes still another thing that is different in common law and in civil law, because in civil law we are used to look at all the circumstances, to interpret a contract. Again, this might go against the desired principle of predictability, because the circumstances are insecure. You might have to rely on witnesses because it was only oral negotiations or the like. So you really, it's not secure. The outcome is not secure if you consider all the circumstances. And that is why common law takes a different stance. If you have a contract that is condensed in a writing, then you have the four corners of the writing, and you may not bring in evidence that is outside the writing. That means you may not rely on prior negotiations that are not in the writing itself, in the contract itself. You may not rely on subsequent behavior of the parties because all that is insecure and would contradict the principle of predictability. So let's have a look at Article 8.3 and decide which group prevailed here, civil law countries or common law countries. Article 8, Para 3. Oh, I'm already on the next slide. Article 8, Para 3 reads, in determining the intent of a party or the understanding a reasonable person would have had, due consideration is to be given to all relevant circumstances of the case, including the negotiations, any practices which the parties have established between themselves, usages, and any subsequent conduct of the parties. That means, in this regard, the civil law countries again prevailed, and not the common law countries with their so-called four-corner rule that only what is in the contract is to be considered when interpreting the contract. So prior and subsequent conduct is to be considered. We have to look at the whole contract and also on the circumstances that are outside of the written contract. Thus, in England we call it the four-corner rule. Does not apply. In the US we talk about parole evidence. The parole evidence rule that you may not rely on evidence outside of the contract is even laid down in the Uniform Commercial Code. So these principles do not apply under the CISG. However, Professor Munoz already mentioned it. I really enjoyed your slide with the big ball of the CISG contract and then the small balls partly covered by the CISG. So he started discussing Article 6. The parties. The CISG is based on party autonomy. That means parties can exclude the application of the CISG, and on freedom of contract. That means they can derogate from any provision. They may vary any provision of the CISG. There are except one exception, which I won't mention, there are no mandatory provisions in the CISG. That means they can also derogate from Article 8, Para 3. Yeah? And they do that very often. Yeah? They can stipulate in their contract that no so-called extrinsic evidence outside of the contract is to be considered when interpreting the contract. And this is done by so-called entire agreement clauses or merger clauses. So the parties are free to do that under Article 6 of the CISG, and with a merger clause, they derogate from Article 8, Para 3 of the CISG. And now our mutis will be very much interested because the contract that they have to deal with contains such a merger clause. And the question is, how are these merger clauses to be interpreted under the CISG? Do they exclude any extrinsic evidence outside of the document, of the contract, or might they maybe be interpreted a bit differently, and we have to decide from case to case what is excluded by the merger clause? Actually, the CISG Advisory Council, in its second opinion, that was in 2002, I think, addressed these questions. It addressed the parallel evidence rule, that the parallel evidence rule is not to be applied under Article 8 of the CISG, and it also addressed merger clauses. And it favored the position that the merger clause has to be interpreted case by case, and that it does not per se exclude any extrinsic evidence. This has been disputed by scholars, so you might have to discuss this question in your respective memoranda. Okay, so oops. I still wanted to, I haven't mentioned, and that is also important for our mutis, Article 8, Para 3, emphasizing that you also have to look at any practices which the parties have established between themselves. So if the parties reacted in a certain way in the past, you might rely on that and argue that there have been practices between the parties to act in a certain way after a cyber attack and develop your answers from there and that is a means for interpreting the contract. You look at the practices between the parties and say, although the contract does not speak about a duty to inform, still there were practices between the parties that show us that such a duty to inform exists. Okay, so next point, what is important also for the interpretation of the contract are practices and usages, not just between the parties, but especially in a certain trade, in the trade where the parties are belonging to. Article 9, Para 1 first tells us the parties are bound by any usage to which they have agreed and by any practices which they have established between themselves. So those are agreed usages. The parties can explicitly agree to a usage. For example, if they use an Incoterm, an Incoterm clause, and they add Incoterms 2020, then they agree on the usage that is given to Incoterms. Then by using 3 letters, they agree to a whole bunch of obligations and legal consequences, just as the passing of risk of loss and so forth. So that would be an agreed usage between the parties. Article 9 goes on with para 2. The parties are considered, unless otherwise agreed, to have impliedly made applicable to their contract or its formation a usage of which the parties knew or ought to have known, and which in international trade is widely known to and regularly observed by parties to contracts of the type involved in the particular trade concerned. So the parties are bound also by international trade usages, and this is an implied implementation into the contract. The parties are deemed to have consented to these international trade usages. This is very important because Article 9.2 still is a means for contract interpretation. The parties are deemed to have had a certain intent. Why do I emphasize it? Because it's different from the French understanding of international trade usages. For French lawyers, an international trade usage is above the contract. So if you were to hierarchize the sources of law, how to apply to a CISG contract, you always start with mandatory law, which you don't have in the CISG, but mandatory law you would have for validity questions. And then you would come under our interpretation, you would come to the contract directly. And then you would interpret the contract according to Article 8 and according also to Article 9, para 2. So international usages, in our understanding, are nothing else but a means to interpret the contract, to find out the common intent of the parties. Whereas under French law, you would start with mandatory statutory rules, and then you would come to international trade usages. And only after that, you would come to the contract as a means for establishing duties and obligations of the parties. And then after the contract come the non-mandatory, always non-mandatory rules of the CISG. Yeah, so that's the hierarchy in France, where international trade usages come before the contract. In all other legal systems that I know, in other civil law legal systems, but also in common law legal systems, international trade usages are part of the interpretation of the contract and nothing more. So what are international trade usages? Well, certainly Incoterms are such international trade usages. So if parties to an international sales contract use FOB and simply FOB and do not specify it by Incoterms 2020, then you could say, well, it's an international trade usage if parties use FOB that they mean Incoterms and not FOB as it is regulated in the Uniform Commercial Code, because the Uniform Commercial Code also has a definition for FOB which differs from Incoterms. Or if the parties to a documentary credit use UCP 600, it's also clear that they use UCP 600 of the ICC. Last point that I wanted to mention, what do we do with linguistic discrepancies? More often than not, a contract is drawn up in different languages. Yeah, because the parties are from different countries, or they use English as one language and then they have another language. And then you might have discrepancies in the two versions of the contract. So which version prevails? That is the big question if you have such differences in the two linguistic versions of a contract. Well, first of all, again, like always, this is also something you will never, ever forget. First, look at the contract. So it's the parties themselves who might tell us in their contract which version prevails in case of discrepancies. I once had a case, actually, where, as an arbitrator, where a contract was drawn up in English and in Italian. And it says, in case of a discrepancy of the two versions, it was between a Swiss and an Italian party. And English law was to apply to the contract. And, we came to the conclusion that English law was to apply to the contract. And the place, there was arbitration under LCIA, London Court of International Arbitration. And the seat of arbitration was London. So everything pointed to London. So the contract said in case of a discrepancy, the English version prevails over the Italian version. Well, and then there was a choice of law clause. And in the English version of the contract, it says, this contract is governed by the laws of Great Britain. Okay? Anybody has any idea why that might be problematical?
Great Britain isn't because the Great Britain isn't in the CISG, right?
No, it was not a CISG case. Actually, it was not a sale of goods. But why is a choice of law calling for the laws of Great Britain problematic?
Well, I suppose there are different laws within Great Britain, English, like Scottish.
Very good, very good. There are no laws of Great Britain. Yeah, they don't exist. There is the law of England and Wales, and there's the law of Scotland. Although in many cases they are similar, you always have in the statutes that are issued, you always have the English and Wales and the Scottish version. And indeed there are differences between Scottish law and English law. So this choice of law clause was, we couldn't do anything with it. We didn't know. Everything pointed to London, that means also to English law. But we couldn't just decide as arbitrators, it's English law. So we turned to the Italian version, which was not to prevail over the English version, but it said legge inglese. So it clearly said the laws of England. So we, as a tribunal, in the end, we got the agreement also by the party who wanted to apply Swiss law. It was the Swiss respondent who said, no, then we have to apply Swiss law. We cannot apply English law. So in the end, the Swiss respondent agreed and we applied English law to the contract, but otherwise this choice of law clause would have been void because we couldn't decide which law. So that's just for an example for linguistic discrepancies. If you do not have a decision in the contract which version will prevail, what would you say? Which version would you look at? Let's say if you have an English version of the contract and an Italian version between a Swiss and Italian party, what would you ask?
It's an interesting issue.
Why?
Because when you have dual language contracts, there's always one contract, one version in which it was originally drafted. Of course, it says that one of them will prevail, but that will not necessarily be the one in which it is drafted and sufficient linguistic competence can be used.
Yeah.
The so-called anchor language.
Yeah. The question is, which was the language of the negotiation? Which was the language of the original drafting of the contract? And we would then apply this version in case of discrepancies. Okay, any questions regarding interpretation of the contract? Yes, please.
Just to confirm, if I've understood correctly, in the example with the Italian version is actually used for Article 8.1 as the true intent of the parties, or was it somehow else?
Well, it was not a CISG contract in that case, yeah. So we didn't come. We applied English law in the end, yeah. Or we had to apply English law.
But the interesting issue is when the contract itself states that the prevailing version is the one which is incompetently translated from something which was evidently drafted in a different language. How do you solve that?
Yeah, that's a problem. I mean, we had that problem, yeah, and the parties just didn't know what they wanted to be super correct by saying Great Britain. They knew it's not only England, it's Great Britain, but they didn't know that there are different legal systems, which also shows that parties usually do not know what they agree upon as the law to be applied to a contract. And that is very important in connection with Article 6 of the CISG. Parties do not know what they opt out from if they opt out from the CISG, because in most instances they opt out from the CISG because they simply do not know it. Yeah, they only know, and they don't neither know what the law is that they choose. Yeah, very often the second mostly chosen law in the world is Swiss law. The number one is English law, and the second mostly chosen law in the world is Swiss law. Why do parties choose Swiss law? They have no idea. They think, oh, Switzerland is a neutral country, so their law must be good. Nonsense, absolutely nonsense. They do not know what they opt out from. The CISG, I once had an arbitration with a contract between an American party and a German party, and what they agreed is, oh, we don't know the CISG, so yeah. And they had a choice of law clause, Swiss law, to the exclusion of any ancestral and unidroit laws. So whoever knows something about unidroit, there are no unidroit laws, yeah, that is soft law. So they had no idea. They just knew, oh, there is something out there like ancestral and unidroit. We do not know what that is, and that's why we don't want it. And they chose Swiss law, and well, the American party was badly advised, actually, because it would have won under the CISG. It lost the case under Swiss law because Swiss law is still based, as many civil law jurisdictions, on the fault principle. That means damages are subject to fault of the contract breacher, and in that case, the seller could prove that it was not at fault, and thus it was not liable in damages, which it would have been under the CISG. So they didn't know what they opted out from, and they didn't know either what they opted into. Okay.
If I may.
Sure.
I think it's fair to be fair to the unidroit principles. And just for the benefit of the students who may not have had classes in this area before, I would like to add one point. While agreeing with everything what you have said, I'm also not a fan of unidroit principles filling in the gaps in the CISG or being the general principles on which the CISG is based. But there's a difference when the CISG is applied before national courts and arbitral tribunals. And the difference is going to be a bit clearer to you once you take the private international law class with Professor Pavic and Professor Jovanovic. But courts are usually bound by the laws of resolution of, conflict of laws rules, and they, in the end, call for the application of the law, state law, law. Whereas arbitrators, when they look at the conflict of law rules and determines which law to apply, usually in most arbitration acts or laws and institutional rules that apply in arbitration, the arbitrators can choose either the law or the rules of law. And here you heard Professor Schwenzer saying how unilateral principles are soft law and fall into the category of rules of law. So if the court is applying the CISG, it most likely in most jurisdictions that I'm aware of, and there might be different jurisdictions in the world, cannot reach or go to unilateral principles anyhow because they're not law. But for the arbitrators, this opportunity arises. And there it would be wrong, in my opinion, and like you heard, I think many members of the council share the view, to apply the unilateral principles as the general principles on which the CISG is based. But in theory, instead of resorting to domestic law, there are no general principles, but we have to go to domestic law, which is a state law of God knows which country, or if the matter is not at all governed by the CISG, but we have to look at the conflict of law that takes us somewhere, it's better to have recourse to unilateral principles than to have recourse to otherwise applicable state law. Because the whole idea is to have this uniform legal framework for conducting international trade, and under all these circumstances and only under these conditions, in my view, recourse to unilateral principles may be justified in connection with the CISG. And sometimes you see in contracts, parties agree on the CISG, even though the CISG would not apply. And then the arbitrators say, well, you see, these parties wanted to have a non-state law governing their contract. And then if there's a gap in the CISG, they say, well, it's only fair if unilateral principles fill in the gap.
Thank you very much for this clarification. I can totally support this position. I mean, the unilateral principles are a complete set of contract law, as contract law is perceived in civil law and in common law jurisdictions. For example, they have rules on limitation of actions, plurality of obligors, plurality of creditors, and, well, illegality. They have rules on validity, yeah? So it is indeed much better to resort to the unilateral principles than to any otherwise applicable domestic law. And that is, and that is advisable also for parties, I mean, to have the CISG plus the unilateral principles, but then it is really necessary to decide where there are external gaps that are matters not governed by the CISG, and then we could turn to the unilateral principles. Okay, do I still have time to start?
No, we have time to start. We have time to complete.
To complete, certainly.
Yeah, but maybe
it will take 2 hours this week.
10 minutes. Can you give the presentation in 10 minutes?
Yeah, I can give you the basics of non-conformity. Article 35 of the CISG is concerned with conformity of the goods. In domestic legal systems, we usually speak about, in civil law jurisdictions, about defects in the goods. What is that? Let's have a look at Article 35, para 1. It says, the seller must deliver goods which are of the quantity, quality, and description required by the contract and which are contained or packaged in the manner required by the contract. This is one of the most important provisions of the CISG because I would estimate in about 80% of the disputes under the CISG, it is a question of conformity of the goods. Yeah, either because the buyer doesn't pay the purchase price the seller sues for the purchase price and the buyer invokes non-conformity of the goods, or the other way around, the buyer has paid the full purchase price and discovers that the goods are non-conforming with the contract and therefore wants either the total purchase price back, voids the contract and wants the total money back, or wants a reduction of the purchase price and wants parts of the purchase price to be reimbursed to it. So it's one of the most important provisions of the CISG. The CISG has a concept unknown to any other legal system before the CISG. Now many legislators around the world, Professor Munoz mentioned it, the CISG has been a blueprint for all domestic amendments of civil codes or code of obligations during the last 20 years, except for one actually, and that was Turkey. Turkey did not rely on the CISG for the amendment of the Code of Obligations, but all the others did, starting with China with the law on obligations or the law on contract, into the Civil Code of China 2020, Japan, Argentina, Commercial Code, Romania, France, Germany in 2002 already. So all the legislators took the CISG and especially also Article 35 as a blueprint to restructure their law of sales, because it's so much better than what we have in domestic legal systems, be it of civil law descent, which is Roman law, yeah? All civil law rules on defects in the goods are based on Roman law, and that means the sale of cattle and slave. I mentioned that this morning. Or common law, which is where the mother of all common law legal systems in sales is the Sale of Goods Act of 1896 in the English Sale of Goods Act. So look at Article 35.1, and that is key. It's a key concept that we are treating different non-conformities alike, different non-conformities that are treated under different approaches in civil law and in common law. What is dealt with in Article 35? It is quality, yeah? That means the quality features of the goods, but it is also quantity of the goods. Then it covers, it says here, the description. That covers what we know under the term of aliud. Have you heard that? Peius and aliud, two terms, Latin terms that also go back to Roman law. Peius is a defective good, and aliud means it's a different good. So if you sell sugar and you deliver salt, this is an aliud. It's something different. Salt is not defective sugar. And what is important in civil law jurisdiction, you have entirely different consequences if you decide that something is an aliud, a different thing, and not a peius. So forget about all this differentiation, about these subtle differences nobody can really make. Under the CISG, aliud and peius are treated the same way. And additionally, you have packaging, yeah? Packaging. There is only one code that I know, that's the Uniform Commercial Code that mentions packaging, but there are no other codes, civil codes or code of obligations that address the question of packaging. So this is a real, I think 35 is a great, great achievement of the CISG. It does away with all these domestic approaches, yeah? In the Sale of Goods Act, and especially deriving from the English Sale of Goods Act, and still in force, for example, in Singapore, in the Australian provinces and territories, in New Zealand, in Hong Kong, you have the distinction between conditions and warranties. And if you have a breach of condition, you may avoid the contract. If you have a breach of warranty, then you can only claim damages. So this is a core distinction under the English law. Under the UCC and also under English law partly, you have express and implied warranties. You don't have conditions in US law, but you have express and implied warranty. In French law and in French legal in system based on French law, you have the distinction between vis apparent and vis caché. That means apparent defects and hidden defects. That is crucial to the question of remedies. In French law, but especially also in Germanic legal systems, you have the distinction between peius and aliud that I already mentioned, yeah? And for example, you have a duty to examine the goods and give notice only if there is a peius. That means if there is a defective good, but not if it is a different kind of goods. Then it is a case of non-delivery, which does not require that you examine the goods and give notice of the fact that the seller did not deliver the goods that were called for under contract, but delivered different goods. Thus, the buyer may sit, and actually in some legal systems, this also affects the statute of limitation. For example, in former times, and still in some Latin American countries, for peius, you have a very, very short statute of limitation, sometimes only a few months. Whereas if it is an aliud that is delivered, you have a statute of limitation of maybe up to 30 years. Yeah.
Do you all know what statute of limitation means? Kako na srpskom kažemo? Zastara. Just check me that.
Okay, so you have the funny result that if the seller of sugar is delivering sugar, let's say, that is contaminated with glass, that would be defective, so it has to examine immediately and give notice immediately. Whereas if the seller delivers salt instead of sugar, the buyer may sit there for 29 years and wait how the market develops, and then after 29 years say, hey, you did not fulfill the contract. There was non-delivery. Please deliver now the sugar that I was expecting under the contract. So really incredible consequences, which are all, we don't have them under the CISG. Under the CISG, peius and aliud are treated the same. Then quantity. Well, and that applies to civil law and to common law. If there is a defect in quantity, how would you treat that under Serbian law? If instead of 100 bottles, only 95 are delivered. Is that a defect within the meaning of your sales law? Well, without knowing the specificities of Serbian law, I don't think it's a defect, yeah? It's a partial non-delivery, yeah? And again, you have different rules for partial non-delivery, it's non-delivery, than for defective delivery. And if we come to packaging, it gets even worse, because packages never is treated as a defect in the goods. Yeah, we have to discuss so-called ancillary duties, ancillary to the contract, and then it's very, very difficult to decide what are the consequences if such ancillary duties are broken. And you see, under domestic legal systems, it's, well, just to frankly speak, it's a mess. Yeah? And everything depends, for example, if you decide, oh, is that a payus or is it an aliud? And that is very difficult to decide. For example, the German Supreme Court once decided that the contract called for winter wheat, seed for winter wheat, but the buyer delivered seed for summer wheat. Well, it was clear. It was more only in springtime the buyer could discover that the wheat was not growing, so it was not winter wheat, it was summer wheat that did not survive the winter. The 6 months limitation period were gone, so the German Supreme Court decided, well, summer wheat is something entirely different from winter wheat. It's an aliud, therefore we apply the rules on non-delivery and not the rules on defectiveness of the goods. So it's really haphazardly that you decide whether the one rules or the other rules apply. So you can see what an achievement it is that we reached with the CISG. It's so much easier to apply the CISG when it comes to non-conformity. I think, well, those would be the basics. Should I stop here and hand over to Edgardo? Or maybe you have
Some questions.
Yeah, some pressing questions you always wanted to know about non-conformity.
You said one domestic law does a bit about packaging.
Yeah, the Uniform Commercial Code mentions packaging. Yeah. In all other legal systems, it's treated as an ancillary duty of the sales contract. It's not part of the goods. Yeah. Well, certainly also in civil law legal systems, it could be part of the goods. If you're buying branded goods, then the packaging is part of the goods, because you cannot on-sell the goods like a perfume or so without the box in which it comes. Further questions you always wanted to know and you never dared to ask?
Well, do you consider misrepresentation to be resolvable under 55? The last year's moot problem.
Misrepresentation, yeah, this is a question of Article 4 again, validity of the contract. Well, we have to distinguish between negligent and fraudulent misrepresentation. Negligent misrepresentation is used in common law legal systems like mistake is used in civil law jurisdictions, and it's inside the CISG, yeah? Because it relates, these cases are governed by Article 35 and should be dealt with by Article 5 and not left to domestic law. Any further questions? If this is not the case, then I thank you very much for your attention.
We can only thank you for your time and for such an elaborate analysis of some of the CISG provisions. And we can also pledge or plead to Martin Lani, advising for international cooperation, to bring Professor Schwenzer to us for a whole semester, not just a day. You know, please send a message to the team. One information before before we take a short break, actually, which seems like, it's about time to have one. All these differences, Professor Schwenzer and other speakers have made reference to the provisions of the CISG in comparison to some civil or common law families or specific national legal systems. There's an interesting book that has been published in Serbian language by Professor Jelena Perović. I do not know the exact title. I have it in my office, and it's published by Službeni glasnik. You can, at any point in time next week, come and find me, and I'll be happy to share this information with you, where she specifically lists or explains these differences where CISG may look to you like the law obligations of Serbia, but entirely, it's an entirely different story underlining it. And if you think like a Serbian lawyer applying the CISG, reading these provisions, you will inevitably make a mistake. Okay, well, once again, many thanks to Professor Schwenzer. 10-minute break, and we'll resume with Đorđević.